A case in front of the U.S. Supreme Court today put North Carolina state lawmakers against state and national voting rights groups. The outcome could determine who decides how elections are run nationwide. WRAL's Capitol Bureau Chief Laura Leslie was in the courtroom for today's arguments and joins us live from Washington, D.C. What happened inside? Laura.
Deb, the experts say that the stakes in this case are extraordinarily high. See, the outcome here at the Supreme Court could allow lawmakers across the country to engage in as much partisan gerrymandering as they want to. Voting protections in the state constitutions across the U.S. could also be at stake. North Carolina Republican lawmakers are arguing that state lawmakers can't be bound by state courts or the state constitution when it comes to election law. They say a clause in the U.S. Constitution gives legislatures sole federal authority to set the time, place, and manner of elections. It's a fringe interpretation called the independent state legislature theory, and the justices seem skeptical. Justice Elena Kagan.
This is a proposal that gets rid of the normal checks and balances on the way big governmental decisions are made in this country. And you might think that it gets rid of all those checks and balances at exactly the time when they are needed most.
That concern was echoed by Neil Katyal, lead attorney for the voting rights groups opposing state lawmakers.
We emphasize to them the extraordinary position that is being taken by the challengers here that would rewrite 233 years and then some of history.
House Speaker Tim Moore is on the challenger side of the case. He and his Republican colleagues were angry when the state Supreme Court threw out their latest round of voting maps, and even angrier when that court ruled that political gerrymandering violates the state constitution.
Yeah, we just felt like the state Supreme Court got it so wrong that we had to do it. And I think the fact that they're even hearing the case shows that the court at least shares some of that concern.
Some conservative justices seemed open to the possibility of overturning the state Supreme Court reading of the state constitution, which would be extremely rare. Justice Samuel Alito questioned whether the court was legislating from the bench when it ruled that the guarantee of free and fair elections requires nonpartisan redistricting.
The North Carolina Supreme Court sets out certain methods that could be used in determining whether there's political gerrymandering, the mean median difference, the efficiency gap, mean simulations. Would anybody have understood that in 1776?
Now, it seems like pretty much the whole legal world of the U.S. weighed in on this one. More than 60 experts and groups filed friend of the court briefs in this case. They ran about 3-1 against North Carolina state lawmakers. We don't expect a decision in this case until probably next summer. Deb?
Fascinating discussion there on Capitol Hill. Laura Leslie live in Washington, D.C. Thanks, Laura.